You sued your doctor for medical malpractice, claiming that he was careless and caused you significant harm and injury. But there's a problem. During the time that you were treating with this doctor whom you have now sued, you were also treating with another doctor and received medications from this other doctor, and you failed to disclose that information to the doctor whom you have sued. Will that come back to bite you in the butt? If you refuse to answer questions about what other doctor you were treating with and what medications you received when you are questioned at your pretrial deposition, will it make a difference? Will it destroy your case? Will it affect your case? Would you like to learn the answer? Come join me on a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is yes, it is going to make a difference. In fact, it's going to make a dramatic difference. So now, you believe that this doctor was careless and caused you harm and injury. The doctor whom you have sued turns around and says, "Why are you suing me? I did nothing wrong. And besides, I had no idea you, the patient, failed to disclose to me that you were being treated by another doctor and were prescribed various medications. Had you filled out the history form, the medical history form completely and accurately, and now you had disclosed that information to me when I questioned you during the course of your visit, I never, ever would have gone ahead and prescribed you various medications that you ultimately took. I never would have given you certain treatment for which you are now claiming you suffered injury from. Why? Because they are contraindicated. And how is I, the physician, supposed to know any of this information? And how is I, the physician, supposed to know any of that information unless you, the patient, disclose that to me in the history form that you filled out before actually walking into the office? And when I asked you if you were taking any medication, when I asked you what other doctors you were treating with, if you failed to give that information to me, how can I, as the physician trying to treat you appropriately, make an educated decision about what to do for you and your particular medical problems? Now, he raises some valid points here. So, leading up to this, you believe that your doctor was careless, causing you significant harm and injury. You found an attorney who had your medical records evaluated by a medical expert who confirmed that you had a valid basis for a case. In the days leading up to the time when you are now going to be questioned by the opposing lawyer who represents the doctor whom you have sued in the process known as a deposition, lawyers also call it an examination before trial. It's pretrial questioning. And now it's a question and answer session that takes place typically in pre-COVID times in your attorney's office. In COVID times, it now takes place on a Zoom video call. The defense attorney is on the call, you will be on the call, I would be on the call, and a court stenographer would be on the call as well to record all of the questions you are asked and all of the answers that you give. Now, you are prepared to tell the opposing lawyer that you are not going to answer questions about the care and treatment you received from this other doctor. You are prepared to tell this lawyer that it's none of his damn business about what medications you were taking before or during the time that you were treating with his client, the doctor whom you have sued. And your attorney tells you straight out, that's a bad strategy. That's a really bad idea. Why? Because the moment you refuse to answer questions that are legally appropriate, that should be answered, that need to be answered, you will raise the interest, you will raise the curiosity factor that this attorney now has. And he will begin to question you even harder and further about why you are refusing to answer these questions, and begin to ask you even more in-depth questions about prior treatment you received, prior medications you were getting, where your prescriptions were filled, what doctors are giving you various medications. Why? Because this is the discovery process, this question and answer session that we call a deposition. And the lawyer, the opposing lawyer, is permitted to ask you hundreds and hundreds of questions about not just the issues in your particular case, but about your background, about your history, about your medical history, about your prescription history, about other doctors you were treating with. And he's permitted to go back a great deal of time and learn a lot of information about you. During this preparation session with your attorney, prior to being questioned by the defense lawyer, your lawyer learns for the very first time, and you share it with him, the fact that you were being treated at the same time, contemporaneously, with another physician who did in fact prescribe you other medications that you did take. Now, the key issue, the key defense in this case is that had the doctor known that you were taking these medications prescribed by another physician, he never, ever would have given you the medications that he did, and he never would have treated you in the manner in which he did. And as a result of that, yes, you did suffer injury. But the doctor was at a distinct disadvantage. Why? Because you, the patient, failed to disclose that critical information to him. And guess what? When you came to the attorney's office, you failed to disclose that information to your attorney. And when the lawyer sent out your medical records to a medical expert to review to see whether or not you had a valid case, guess what? There was nothing in the doctor's medical records to confirm that you were being treated by somebody else, that you were receiving other medication that contradicted or was contraindicated to the medications that this doctor was prescribing for you. So our expert came to the erroneous conclusion that you had a valid basis for a case. Why? Because this time you failed to disclose that information to your attorney. And by doing so, the attorney relied on his expert, who relied on the medical records that you provided, and guess what? He came to the wrong conclusion. Had you told the attorney that yes, you were being treated by another doctor who gave you these medications and they were contraindicated compared to the medications that the doctor was getting, and that you failed to tell your doctor about that, your attorney never, ever would have accepted you as a client. The medical expert never would have said you had a valid case, and in fact, he would have said you don't have a valid case. So what happens now? You have not yet reached the deposition. You still have another few days to go, but you are psyched up in your mind that you have a valid case. And you're saying to the attorney, I want to go forward with the deposition. I know in my heart of heart I have a good case, and nobody's going to stop me. And you know what your attorney will say and should say? He's going to say, listen, Mr. Jones, I'm sorry. I'm going to have to withdraw as your attorney. We're going to bust this deposition. We're going to cancel it. And there is no possible way I'm going to allow you to testify in this pretrial deposition where I know for a fact that you failed to disclose this information. I now know that you don't have a valid basis for a case, and there is no possible way I'm going to allow you to testify on your own behalf. That would be totally improper. And that's exactly what the attorney should do. So, going back to the title of this video, will it make a difference if you failed to disclose this information to the doctor and now you are refusing to go ahead and anticipating what questions you will be asked and refusing to answer those questions? Will it make a difference? Absolutely. So why do I share this information with you? I share it with you just to open your eyes and give you a bit of insight into what really happens in these medical malpractice cases, these accident cases, and even these wrongful death cases in New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're considering bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.